Hello friends, today we're going to discuss about NEET exams, next exams and National Register for Medical Practitioners under National Medical Commission Act of 2019. I'm Dr. Suresh Vadadmat, Professor of Psychiatry, working at National Institute of Mental Health and Neurosciences, Bangalore. In this video, I'll be discussing about NEET exam, next exam and National Register for Medical Practitioners. National Medical Commission Act of 2019 was passed on 8th of August 2019. If you look at the chapterization of the legislation, there are 8 chapters which has 61 sections. If you look at the organogram, that is statutory bodies under the National Medical Commission Act, there is a topmost body which is called as National Medical Commission, which has 33 members including the chairperson. This National Medical Commission is advised by a council called as MAC, that is Medical Advisory Council. Further, there are 4 autonomous boards, that is UG Board, PG Board, Medical Assessment and Rating Board, and finally Ethics and Medical Registration Board. Now let's understand the Chapter 4, which is National Examination, which are dictated from Section 14 to Section 15, my dear friends. Let's look into the national examinations. That is National Examination for Medical Education. The National Medical Commission shall conduct the NEET exam, that is National Eligibility-cum-entrance test for undergraduates, my dear friend. That means without NEET exam, nobody can join medical college to become a doctor. Further, it also says a common final year undergraduate medical examination, considered as NEXT, also called as National Exit Test, shall be the granting license to practice medicine as a medical practitioner and for enrollment in the state register or the national register, as the case may be, within 3 years of passing this National Medical Commission Act. That means there will be 2 exams. One is NEET, another one is next exam. This national exit test shall be the basis for admission for PG and super specialty also. Any person with foreign medical qualification have to pass national exit test, my dear friends. The central government shall conduct this common counselling for all India seats, and designated authority of the state government shall conduct the common counselling for the states at the state level, my dear friends. Let's understand the process of national examination, my dear friends. First and the foremost, to join MBBS course, there is NEET exam, that is National Eligibility-cum-entrance test, my dear friends. And before they enter into the internship, that means they need to pass the MBBS. To pass MBBS, there will be next exam 1 or phase 1 will be conducted. Once the next exam 1 is passed, they will be given a provisional registration to practice internship. Once they have passed or finished their internship, they need to take next exam 2. This next exam 2 will give them the permanent registration and also registration either under the NMC or State Medical Council. This next 2 exam will be the basis for joining post-graduation, my dear friends. That means National Medical Commission will conduct 3 important national exams, that is NEET, next exam 1 and next exam 2, my dear friends. Now let's look into the autonomous boards, which are from Section 16 to Section 34. They are under the Chapter 5, my dear friends. These are the various boards which are formed: Undergraduate Board, Postgraduate Board, Medical Assessment and Rating Board, and finally Ethics and Medical Registration Board. These are the 4 boards which are formed under the National Medical Commission Act, my dear friends. Let's look into the National Register, which are dictated by Section 31. The Ethics and Medical Registration Board shall maintain a national register for registered medical practitioner. This register will be maintained both physical and electronic form as described under the regulation. The manner of entry and removal of the name into this register will be dictated by the regulation, that is, ethics regulation, my dear friends. This national register will be a public document, and EMRB will make all efforts to make it public and place them in the public domain, either in the website of EMRB or NMC, my dear friends. Every state medical commission shall maintain and regularly update the state medical register in the specified electronic format and supply a physical copy of the same to the medical registration board. Of course, in the era of digital, you may ask why there should be a physical copy. Of course, at this point of time, we need to have a physical copy, my dear friends. Of course, nowadays we have amazing digital technology like blockchain development, which may help in reducing the physical copy, my dear friends. But however, this legislation says both electronic and physical copy should be maintained by the State Medical Council. EMRB shall ensure electronic synchronization of National Register and the State Register, which is maintained by the State Medical Council. That means State Medical Council, which maintains the State Register, and the National Medical Commission, which maintains the National Register, they should be synchronizing. That means whatever the changes made in the State Medical Council will be depicted under the National Medical Commission, my dear friend. EMRB shall maintain a separate national register for community health providers, my dear friend. However, one need to understand there is a national register, but there is a license to practice under Section 33. Under Section 33, right of a person to have a license to practice need to be enrolled either in the national register or in the state register, and they need to fulfill certain obligation. Any person who qualifies the next exam, that is national exit test, shall be granted a license to practice medicine and shall have his name and qualification enrolled either in the national register or in the state register. However, this is separate from the national register or a state register. There is registration, that is one-time registration, which will occur at the National Medical Commission or maybe at the State Medical Commission. And there is a license to practice which will be given by the respective states, my dear friends. Foreign medical graduates who are passing their MBBS from the foreign institution need to qualify the next exam, both next exam 1 and 2, my dear friend, to enter their name into national register, and they need to take license from the State Medical Council to practice medicine in their respective states. If a registered person shall be entitled to have such title, diploma or qualification entered into the state register or national register, with those qualification needs to be approved by the NMC, my dear friend. Section 34 talks about bar to practice. No person other than a person who is enrolled in either in the state register or in the national register can practice allopathy, my dear friend. He will be allowed to practice medicine, and he can hold an office as a physician or a surgeon in any government. And he is entitled to sign or authenticate or to give a medical certificate, fitness certificate, or any other certificate required by the law so that he can sign it and produce it to the respective authorities, my dear friend. That means NMC gives power to the registered medical practitioner to give certificate, my dear friends. The RMP is also entitled to give evidence at any inquest or in any court of law as an expert under the Section 45 of the Indian Evidence Act. That means NMC gives power to the registered medical practitioner to give evidence. Any person who contravenes any of the provision of this section shall be punished with imprisonment for a term which may extend to 1 year, or with fine which may extend up to 5 lakh rupees, my dear friends, or maybe both. That means National Medical Commission Act Section 34 bars practicing allopathy by any other person other than a person who is registered under State Medical Commission or National Medical Commission. Chapter 6 discusses, especially with Section 35, recognition of medical qualification granted by universities or medical institution of India. That means No colleges or universities will give any degrees which are not approved by NMC. Even if they give, NMC will not recognize such degrees or qualification. Recognition of medical qualification comes under Chapter 6 and they are dictated from Section 35 to Section 40. Recognition of medical qualification granted by universities and medical institution of India has to be approved by respective boards. That is, either it may be UG board, PG board to recognize them. You cannot start a new course without the permission of NMC, my dear friends. The UG board and PG board shall maintain a list of recognized qualification for the purpose of the Act. Any university or medical institution may apply to the respective board for granting recognition of such courses. If they want to start a UG course, they need to apply to UG board. And if you want to apply for a new PG course, you need to apply for PG Medical Education Board. UG and PG board shall examine the application within 6 months and decide to approve or disapprove that course. If approved, it will be entered into the list of recognized qualification and the date of entry. If rejected, the applicant can choose to appeal to the NMC within 60 days. NMC shall examine and direct the respective boards to approve or uphold the decision. If NMC rejects the application, the applicant can approach the central government within 30 days. Similarly, Section 36 talks about recognition of medical qualification granted by universities or medical institutions outside the India, my dear friends. Any country outside the India, which by the law of their country has been running certain courses, they can approach the National Medical Commission to recognize these new courses or the degrees. These medical qualifications should be approved by that country. Then only they can apply in India through that agencies only. The commission can refuse to accept those qualifications. If they refuse, then they can approach the central government against the NMC's decision, my dear friend. If it is granted, then such qualification from the foreign countries will be approved and they will be available for NMC, and such a medical practitioner can practice in India by putting those qualification in front of their name. Section 37 talks about recognition of medical qualification granted by statutory bodies or other body in India. Section 37 is very clear. The medical qualifications granted by any statutory or other bodies which are maintained under the schedule. These schedules which talks about All India Institute of Medical Science Act, PGI qualifications, JIPMER qualification, NIMANS qualification, DNB or NBA qualification. All these 5 bodies are under the statute passed by the Parliament of India, my dear friends. Apart from DNB or NBA, that is under the Society Act, my dear friends. Now, the NMC Act is very clear. Any degrees given by these 5 institutions need to be recognized by NMC. DNB, recognized qualifications given by the NBA, that is National Board Examination, has to be recognized by the NMC for teacher if the hospital has a strength of 500 or more beds, and that will be considered as equivalent to MD or MS. In all other cases where if that National Medical Examination or DNB, where the beds strength is less than 500, those students who pass from such institution shall do 1 year senior residency to be considered as equivalent to MD or MS. This applies only for DNB students, my dear friend. Section 38 talks about withdrawal of recognition granted for these medical qualifications by the NMC or by the boards. After the MARB assessment, that is Medical Assessment and Rating Board, if they have assessed, a report will be submitted to the commission about the university or the medical institution not to recognize such courses or postgraduates or UG will be submitted to NMC. NMC invariably will give an opportunity to listen to them, or else they may impose penalty against them if they continue to violate the regulations, or else it is a gross violation is there. The commission shall hold a consultation with the respective state government and the authority of the concerned university or medical institution, and they will withdraw the permission or license to keep the college. The withdrawal of recognition or granted to medical qualification granted by medical institution outside the India will be by the NMC. NMC will decide about the withdrawal of recognition. Section 40 also talks about NMC may recognize certain qualification granted by medical institution outside India, but the graduate needs to pass the next exam, my dear friends. But however, there is a one contentious issue, that is Section 32, that is community health providers. Section 32 of National Medical Commission Act, which is opposed by most of the MBBS doctors, that is community health provider section. Here, the National Medical Commission can grant a limited license to practice medicine at the mid-level community health provider to such person connected with modern scientific medical profession who qualifies such criteria as may be specified by the regulation, provided that the number of limited license to be granted shall not be exceed 1/3 of the total number of licensed medical practitioner. That means National Medical Commission gives community health providers, it can be nurse practitioners, or maybe community health workers, or maybe even voice doctors, after undergoing certain training, which may be specified by the regulations, can practice limited allopathy. The community health providers who is granted limited license may practice medicine to such an extent, in such circumstances, for such period as specified by the regulation. The community health providers may prescribe specified medicine independently, only in primary or preventive health care, but in case rather than primary and preventive health care, if they want to do, that needs to be supervised by a medical practitioners. And this community health provider has been opposed by Indian Medical Association, various doctors, various medical colleges, because this is a backdoor entry to practice allopathy, has been the allegation by the doctors against NMC. Now let's look into the miscellaneous sections of the NMC, which is dictated from section 45 to section 61. Section 49, completion of courses of studies in medical institution. If a recognition granted to a medical institution is lapsed for both either UG or PG for any reasons, either maybe not meeting the standards, or the faculties are not there, or the health hospital is not there, or something has gone wrong, such medical institution shall continue to maintain and provide the minimum standards required to be provided under this act till such time as candidates who are admitted in the medical institution complete their education. The year that institute gets degree recognized, from that day onwards, they will not do any admission either for UG or PG. Imagine, in 2013, a medical colleges, their recognition is withdrawn. However, there are already students who are undergoing either UG or PG. Those will continue to do their education and they will be given recognition. However, from 2023, that institution will never admit unless they meet the criteria of our UG or PG board, and the MARB will give the permission to start the courses. That means it is very clear. Just because in 2023 the college loses recognition does not mean the students who are undergoing graduation or post-graduation will not be de-recognized. The state government under Section 51 will promote primary health care in rural areas. Every state government, depending upon their health human resources, for the purpose of addressing and promoting primary health care in rural areas, can take necessary measure to enhance the capacity of healthcare professionals. That means either through community health providers or they can start various other courses. And NMC may look into the matter and they may provide recognition. The chairperson Members and office of the commissions and autonomous board will be considered as a public servants, my dear friends. Section 53 gives protection of action taken in good faith by these public servants. Further, Section 54 talks about cognizable offense. That means no court shall take the cognizance of any offense punishable under this act, except upon complaint in writing mode or made in this by a officer on behalf of National Medical Commission or AMRB board or State Medical Council under Section 54 of this legislation. Further, Section 55 talks about powers of the central government to supersede the commission. That means if the commission is not functioning properly, the central government can dissolve the National Medical Commission and take over the NMC, my dear friend. Section 56 talks about the central government to make rules, power to make rules, and Section 57, power to make regulation. Section 61 is a transitory provision. That means nothing withstand or nothing will be stopping by the repeal of the Indian Medical Council Act of 1956. The educational standards, requirements, and other provision of the NMC Act of 1956, the rules, regulation made under that shall continue to exist and will be in force until that day when NMC makes new rules, regulation, guidelines. Till then, although the act may be repealed, those regulations and guidelines will continue to be enforceable under the law till the date NMC makes new rules and regulation. To conclude, my dear friends, NMC Act of 2019 is a paradigm shift from IMC to NMC, which is a public pro legislation. Although health is a state subject, NMC has taken a bold step to form a comprehensive legislation. This is a high time we need to move the health from the state register or the list to central register, at least to the concurrent list, my dear friends, so that the citizen of India can enjoy a good health and access to good health care. Although this legislation is new, need time to implement. The legislation is implemented through NMC and also 4 autonomous boards and State Medical Council. These are the various bodies or statutory bodies under National Medical Commission Act, that is NMC Act body, and MAC, that is a Medical Advisory Council, and 4 autonomous board, including State Medical Council, which will implement this legislation, my dear friends. Thank you very much for giving your valuable time. Stay safe.